Okay, thank you so much.
You're welcome.
Kathini, then Naomi, we will extend just maybe with maximum 15 minutes. Kathini, Naomi, then we go to the chat. I've seen there are questions in the chat as well.
Okay, thank you so much. Miss Ruth, I am one of your biggest fans on YouTube, so shout out to you. I really enjoy your channel and
Thank
all
you so
the
much.
collaborations you have done. You're welcome. I would just like to ask about legal reform. You have highlighted some of the loopholes. So what can we do to make our legal regime in regards to conveyancing better? I just wanted to ask that.
Okay, I think it's going to take a first by day, because I think it's going to be a process, but I think we're already starting doing that, because like this conversion of titles, you know, they were saying you have to get a title under GLA, you have a title under RTA, you have a title under RLA, but you know, as you all know, the conversion will mean all the title deals will be under the Land Registration Act. So I think this is one of the steps that is going to help, where all title deeds will be under one title. So that will save a lot of, to avoid a lot of, it will, like you see now, like even at the registries, you find, especially if you have a GLA title, it's normally a hassle to do a search, because you find some documents are missing, because you have to, and like these other titles that have a green card, which has like all the proprietors, you know who, or like it has all the information, it's normally so difficult. So I think this conversion is one of the steps that will help in covering the loopholes that are already there. And then another thing I think I've realized, though I think it's going to take time, the land registries. Currently they're like, remember, I don't know if people knew that Ngong Land Registry was closed like for 2 months, because they were trying to do some changes here and there. And the next time we went there, at least you could see there's some changes. Normally at Ngong, you find you have a transfer, your clerk has gone there, there's no franking machine. So the document has to be franked, or the franking machine is not working. You can imagine such a scenario. So someone has to come back to Nairobi Land Registry to frank the document. You also find maybe in Gatundu, they don't have a franking machine, Gatundu Gatundu Land Registry. So you find everyone has to frank the document here. So those are some of the things that I think this cabinet secretary, the land cabinet secretary is trying to solve. And then the thing where we are taking things online, I don't think as such I should have to go to the land registry to do a search. So I think, despite the fact that it is having a lot of problems, but anyway, I think we should not criticize it much. At least we're seeing it's a step. I'm sure with time, just like the online courts, it had issues when we are transforming to online, but with time we are trying to solve them, or the way we are finding matters online. So I think we are heading there. Loopholes are like what is happening. I think there are some steps that are being taken compared to before. Because before doing a search, you could even wait for 2 weeks. So I like the fact that they're trying to put everything online where you can just do a search online. I think it's a good thing, because I don't think you have to go to lands to just conduct a search, just a very normal search. So that is going to help, or even for people in the diaspora who are buying property in Kenya. So you can do your own search there. Because some people, they fail to do that step because they didn't have someone to do for them a search in Kenya. So I think, those things I've stated, I think those are some of the things, steps that we are going towards solving the loopholes that are in our land regime in Kenya.
Thank you.
Thank you.
So Naomi, go ahead, then Peter. Those are the last ones, then we go to the chat, and then we close the meeting. Naomi?
Yes, thank you for this opportunity. I've got 2 questions, and I hate to take you back. You earlier mentioned about, someone asked about a search, and I think you addressed this, but I've got another question about it. So suppose of course, when you do a search and it's provided under, the rules and regulations, that an official search basically should give you something to rely on, that, whatever information is put there is correct according to the official records. So should anything happen, for example, later on you find that probably there was some mistake or some inappropriate action that probably led to the title, or it just, how do I say, lack of a better word, it like negatively affects the whole search thing and the whole title passing. And on the basis of the information you got upon the official search, you've got a good title and all that. Then you said you can sue the registrar, of course. And then my question is, and you brought out the issue of a green card that shows the history of who's been holding this land, all the people that have that title all the way through. So then in such a case, could you actually get good title, or you're just suing for something like convenience? Because, you know, you relied on this search and it's official and it's meant to give you the correct information. So can you sue and actually get good title, despite the fact that, you know, the title was encumbered, you know, under, well, the new evidence? And then my other question is, you talked about professional undertaking, that you can put a clause in there to, like, for instances that you probably had not envisioned or something that goes wrong. Someone asked about receivership, but then I don't know, the way my lecturer taught me, I thought I got it a little, well, I don't know if I got it a little mixed up, but the idea that I got there is that you have to be, you as an advocate, you have to be in control of that money, of the circumstances in which you're giving the professional undertaking. So should you give a professional undertaking, then the bank later goes on receivership, then you'll still be bound. Even so, I'm just wondering, would you actually put a clause there? Would it serve the purpose of a professional undertaking? Why would someone choose to rely, you know, on your promise on a professional undertaking when you've put there a clause that should this bank go into receivership, then I won't be bound? Does that actually call a professional undertaking? It could actually be any promise, you know, exchange between any person. But I don't know, I have a reservation towards, and I stand guided, of course, towards actually, you know, putting in a clause that would give you leeway to, you know, to get out of your obligations because of something that has happened that is out of your control. Thank you.
Oh, excuse me, you're muted.
Oh my God, I'd finished my question. I don't know if you guys have not heard me.
We haven't heard anything.
What?
We've heard.
I've heard.
Yeah, I had your.
Okay, maybe.
I had your question, or you can summarize it.
Oh,
Hello.
okay.
You can.
I don't know. I don't know. If I can be heard right now.
Yes, we can hear you. Oh, I was saying, Madam Ruth Tanui was muted, so she was supposed to respond to your question.
But yeah, but I had Naomi's question, so that's why I was trying to respond to it. So what I was trying to tell Naomi is, you know, you don't put a clause like specifically stating that if I don't honor this clause, this is not going to happen. It's normally just more of protecting in case of anything. But and remember also, professional undertaking normally take place by the time, even not like, even especially banks, they don't give all advocates, they don't like trust all advocates when it comes to professional undertaking. It normally depends with, that's why even a profession, well, giving a professional undertaking, you must have a license, you must be a licensed advocate. Like they normally even ask for the current practicing certificate. So it's that something, you know, because they're going to trust you on your word. So mostly you find most banks, I'm just, let me give an example of banks because that's the one that we have dealt with mostly. When they're giving another advocate a financial undertaking, they have a relationship. We find even that law, the conveyancing law, the conveyancing law firm is part of the panel in their bank. So that's what I was trying. But that's another thing first I need to specify. And then you don't, what they normally just state in case something happens. You know, there's normally, you know, something that was unforeseeable. You normally just put something just to protect yourself. In case this thing doesn't happen, this is what's going to happen. But of course, you don't put like the way of saying a clause like stating, like if in case receivership, like if the bank goes on receivership, this is what's going to happen. So, but I think this one, the best thing is, I think because there's been contention here, I think if Angie will allow, we can create a like another session where we'll only talk about professional undertaking.
Most certainly, most certainly.
I think that will be better. We'll have a session only strictly on professional undertaking.
Okay, now the last question from Peter, then I go to I'll skim through the chat, then we end. Peter?
Okay.
Thank you. First, may I say Heko for the informative lecture from the advocate. I think other than life, the other thing that is very emotional is issues of land, and land conveyancing is becoming a very hectic aspect. My question is on how do advocates cushion themselves from the presence of land grabbers? You talked about searches. Currently, we are seeing digital searches where even land registrars are able to run away from responsibilities, because there is with the digital one, there is already a configured signature, so that there is a lot of collusion between the large registry personnel and the purported vendors, so that we are finding so many processes, even if they have gone through the due process up to the agreement, you find all the way after the money have changed hands, another buyer, another owner survises, and through to the situation, he is the owner of the land. Other people are subdividing other people's lands without their knowledge. They get titles, these titles or certificate of titles, and they sell to unsuspecting buyers. Only after you have gone through the process and have an advocate, when your client goes to now improve on the property, another buyer suffices. And true to the effect, you find he is the real owner. We have had scenarios where we have several titles, all of them original on the same property. Within this environment, how is the advocate able to caution themselves, and how are they also able to caution their clients? That would be my question. Thank you.
Okay, thank you for your question. So what I can say on this, by the it's never guaranteed. You have said you may take all the steps. So as an advocate, like for me, let me use myself as an example. What I normally do, the moment first, I can't take a client who has already started the process without me, and it's because some clients will decide, because they feel the advocate is so expensive, they'll come back, because there's a client who looked for me after buying, I don't know if people have heard about this property, of the Tattoo City property. The client had already paid, I think it was going for 3 million. The client had already paid, even before signing the sale agreement. Upon being given the offer letter, the client had already paid 500,000. So, already, and then by the moment she told me about the Tattoo City, I knew there was an issue, because I remember Kabogo say there was a case in court where Kabogo had held, there was an issue of like ownership and everything. So Kabogo held the original titles of those properties. So I already knew there was an issue. So another thing, the biggest question also I also make sure is I take clients where you start with them. Because not such a client, it's already, like I was even telling her, the best thing maybe you can do for her is, because first there was no sale agreement, so I tell the client the truth, sale agreement, and even the offer letter, she didn't sign it. So I was telling her, getting back your money in such a scenario is going to be hard, because even here you're not even at the level where you're dealing with the advocate. So anyway, the first thing I normally do is when dealing with the client, I prefer, because when there's some clients who come to you telling you, I just want you to do for me. I'll do the search, I'll do the land visit. I just want you to draft the sale agreement for me. I don't also take such clients.